I mean, how are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you.
All
Did
right. This one is messy from the very first line, because the court isn't dealing with a simple co-parenting disagreement. It's dealing with a violent felony case and a probation violation stack, so long it reads like a checklist of warnings that got ignored. The judge is trying to separate fantasy from reality. You don't get to argue. We need to communicate for the kids. While there's an allegation of assault, repeated no-contact violations, failed programs, drug issues, and even accusations of trying to manipulate drug testing. That's the core tension here. Two people still acting like they're in a relationship dynamic, while the court is treating it like what it legally is, a public safety and compliance crisis. And look at how the judge runs it. Rapid-fire, true or not true questions. That's not the judge being rude. That's the judge locking in the record. Probation revocations often come down to what you admit and what you deny, because admissions simplify proof. This hearing is basically the system saying, we already gave you structure. You ignored it. Now we decide if you keep your freedom. And the wild part? The victim's choices are going to be questioned too, not as blame, but because the court is trying to stop the cycle before it turns into something worse. Question for you. If both sides keep breaking the boundaries, should the court step in?
Did you admit to your probation officer did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Well, in cause number 24, DCCR 1008, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to immediately report to the community supervision officer your contact information. And is that true or not true?
I failed to. True or not?
It's just true or not true. You can explain later. So did you give them your contact information or not?
Yes, ma'am.
You did give it to them?
Yes, ma'am.
Okay, so that's not true. Count 2 alleges that you provided a urine sample May 29th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 3 alleges that you provided a urine sample July 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you were at a location other than your residence at approximately 3:10 a.m. and 4:55 a.m. on July 10th of 2025 in violation of probation. Is that true or not true?
True.
Count 5 alleges that you failed to provide all records and documents required by the supervision officer within 30 days of their instruction. Is that true or not true?
Not true.
Count 6 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Have you done the BIP program?
No, ma'am.
Okay. So that would be true that you haven't successfully completed it, right? Okay.
Commentary view
Count
of this
7
is where probation gets real. People hear probation and think it's just stay out of trouble. No. Probation is a contract with teeth, and the court is checking compliance like an audit. The judge goes count by count. Contact info, positive THC tests, being out away from home in the middle of the night, missing documents, and then the big one, the BIP program. When you're on deferred probation for aggravated assault with a deadly weapon, battering intervention isn't a casual suggestion. It's the court's way of saying, if violence is part of your pattern, you're going to address it or you're going to jail. And notice something. The defendant keeps trying to explain early, and the judge shuts it down until the facts are locked in. That's strategic. Once the court gets true admissions, the conversation changes from did it happen to what do we do about it? And failing BIP is a giant red flag because it tells the judge you're not investing in the one thing that might lower risk, accountability and behavior change. So here's the question. If someone won't do the classes designed to prevent repeat violence, how can a judge?
Count 7 alleges that you failed to
I think I should say not in there, Judge. I'm sorry. He felt to not have any communication.
State wish to amend that to say not on number 7.
Yes, Judge.
Failed to not, any objection?
Objection.
So 7. Hold on, let me make that. I'm printing it because it'll be easier for me. All right, so 7 says that you failed to not have all communication with the victim regarding your child through an approved third party by repeatedly appearing at the victim's house to, quote, see your children. Is that true or not true? Of 2025, and is that true or not true?
True.
You understand adulteration means? And the court could explain adult, I don't think.
I mean, did you show up to probation and do either a fake urine sample or have some type of, what was it,
He admitted to drinking something that made his urine negative.
gotcha. So did you do that?
No.
You didn't? You just admitted it, but you didn't really do it?
Did you say it, or did you say that, or not? That you admitted to drinking?
So it says you admitted to the adulteration of your urine analysis, that which means you told your probation officer that you did something to make your urine analysis negative. Is that true or not true?
Well, any piss test I
Urine
had.
test.
Listen.
Any urine test I failed with.
Listen to my question. I don't care about any of that.
Yes, ma'am.
Did you admit to your probation officer
Not that I
that
know.
did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Okay.
Let's say not true, Your Honor.
Count 10, let's see. Actually, count 9. Hold on, I'm out of 5, 6, 7, 8. What I missed here? Count 9, so this goes over here, alleges that you had contact with the victim of the offense, either in person, by telephone, via mail, or through a third party several times after being put on probation in violation of your order. Is that true or not true?
Can you say it again?
Have you had contact with the victim of the offense?
True.
And then count 10 alleges you are behind in your court-assessed fees as of July 17th, 2025, in the amount of $337. And is that true or not true?
True.
Involuntarily.
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So we've got, I'm going to find those counts true. Ms. Lopez is here. What? Let me look back at something real quick.
David? August 18th was his last drug test, and he tested positive for THC. He has since been drug tested again in September, and it was negative. I gave you the wrong date there.
And I think the concern, if Ms. Lopez can kind of go into a little bit more detail about our conversation, is that he may be using synthetic, which doesn't show on the tests at probation. And then obviously issue with
We're in the danger zone, not just drug use, but possible manipulation and risk escalation. The court hears that he was positive for THC on August 18th, then later tested negative. But probation's concern is he might be using synthetics that don't show on routine tests. Whether that's true or not, you can hear why probation is nervous. If testing isn't reliable, supervision becomes guesswork, and guesswork doesn't protect victims. Add to that the accusation of urine adulteration, drinking something to make it clean, and the judge is basically saying, stop dancing around it. Yes or no? Because if someone is trying to beat tests, they're not trying to get better, they're trying to avoid consequences. Then comes the relationship chaos. The officer says the complainant called and admitted they were seeing each other that same day, and it's inconsistent whether she wants to be around him. That doesn't mean she's at fault. It means the situation is unstable and emotionally volatile, which is exactly when violence reoccurs. Courts hate inconsistency because it creates openings for contact, pressure, manipulation, and danger. So when the judge says, "You're the one who can go to jail," that's not attitude. That's the law. The defendant is under orders. What do you think? Should the court treat "we still see each other sometimes" as a reason for more flexibility, or as proof the boundaries are failing?
issue with the no contact, which is why I have the complainant here. I don't think either one of them are adhering to that.
So Last known contact that you know of that's not in here, has there been any?
I was called by the complainant on Thursday of last week, and she admitted that they had been seeing each other that day. And she was angry, but it's very inconsistent whether she wants to be around him or not. Some days I get called.
Well, but I told you,
To come back in front of you.
Just be quiet, listen.
I told you can't have contact.
Yes, ma'am.
And you're the one that can go to jail.
Yes, ma'am.
Okay, based on all of these allegations, I realized that I reinstated a bond and we had a hearing, it looks like, where I ordered some spindle top, but it sounds like this is not going in a safe direction at this point for anyone. At this point, I'm going to find that it is in the best interest of our community, best interest of the victim, and based on all of the factors, in 15.17 and the fact that you're on probation for an aggravated assault with a deadly weapon, I am going to make this, at this point, a no bond. You will go back with the bailiff. I'll reset your case for cases that are still pending. If you have any witnesses, then...
Since she's here, do you want to elicit testimony from the victim or not? She is
Judge,
here.
what my preference would be, may she come up to be addressed by the court?
Yeah.
Ms. Bell?
1 minute, 37 seconds later.
The nature of this plea originally, Judge, was obviously a little bit low. It was based on some cooperation, non-cooperation, cooperation, non-cooperation, which I believe is still the case. I don't know what...
Look this way.
What is... I don't
You
know the
look this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through this no contact order about voluntarily engaging.
I think they got children together as well, is that right?
Well, that's why...
They're pregnant now, is that right?
But that's why I made the specific rule that they go through a third party to transfer kids, to see
And
kids.
the problem is that the third party is his mother,
What are you talking about? That's not how it works.
which is, I've told him multiple times, cannot be.
Cannot be. Okay.
It's not working.
You are pregnant with this child right now?
Yes, sir.
Okay.
So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? Whenever I did call the probation officer, technically he was already staying at the house. We both our managers are in the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because, me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go, and obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there, and that's why you called?
Yes, ma'am.
Okay,
But
then
he's
it's,
been staying there.
all right, well, then you know what you have to do. You're the one
I
on,
got out the house and I waited on my ride before my ride came.
Well, if you're staying at the house, and you're, I'm resetting it for a sentencing hearing. If there's any test, we'll come back.
Your Honor, I would implore the court to admonish them that contact includes calls from the jail.
It does. Contact, communication. Contact doesn't just mean in person, all right? It means communication. So you can't call her from the jail. You can't talk to her, period.
Man, we have children together.
And so, really?
We have 4 kids together. I'm going to have another child for him. How are we supposed to? How are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Man, we're ready to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's the choice that you're making to still be with somebody that assaulted. You can go back, go.
Thank you, Judge.
You can go with the bailiff.
This ending is the court drawing the hardest line it can draw, no bond. And it didn't come out of nowhere. The judge stacks the reasons: repeated violations, ongoing contact, failure to complete required classes, drug concerns, and the underlying reality. This is probation for aggravated assault with a deadly weapon. When the court believes the situation is not going in a safe direction, the priority shifts from convenience to containment. People hate hearing that, but the judge says it plainly. Right now, this isn't co-parenting. This is safety for the victim, the unborn baby, and the children, until the court sees consistent rule following. And the victim's testimony adds the final layer: shared housing, confusion over who's supposed to leave, calling probation, waiting for a ride. These are real-life details that show how easily no contact turns into contact. Then the judge clarifies something the public always misses. Contact includes calls, messages, third parties, not just seeing each other in person. The court is basically saying, if you keep breaking the boundary becomes jail. Final takeaway: when probation conditions are ignored, the court stops negotiating and starts enforcing. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.